it pleases the court, Your Honour, my name is Pointing, initial B, and I appear for the defendant, Johnny Wishbone, in this matter. Before advancing my argument, I wish to tender my submissions to the court in pursuit of my case. The legal issues before the court today are firstly, whether the police adhere to the relevant sections of the Police Powers and Responsibilities Act 2004, hereafter PPRA, and Responsibilities Code under Schedule 9 of the Police Powers and Responsibilities Regulation 2012, hereafter PPR, while questioning my client, an Indigenous juvenile, and secondly, whether in the surrounding circumstances, the evidence tendered by the Crown should not be allowed into evidence against my client due to its inadmissibility. The defence will now put forward argument to establish the legal basis of the application for inadmissibility of the Crown's evidence. Your Honour, I submit that during the course of questioning my client, the police failed to meet their statutory obligations under the PPRA and PPR pertinent to the questioning of an Indigenous child. My client was born on 29 June 2000 and was therefore aged 16 and deemed a child for the purposes of Schedule 4 of the Youth Justices Act 1992 at the time of his arrest and questioning by police. Furthermore, he identifies as a Torres Strait Islander person. Your Honour, I submit that these facts were evident throughout the impugn questioning. Your Honour, for the purposes of clarity, I would like to recount the factual circumstances which have led to the issues in dispute today. The police proceeded to arrest and question my client at the property located at 2 Smith Street in suburbia. It was at this time that the police was informed of the age and ethnic origin of my client. Although the police lawfully arrested my client pursuant to Section 391 of the PPRA, I wish to direct Your Honour's attention to Section 431 of the PPRA and Section 26 of the PPR. Section 431 of the PPRA states that a police officer must, before a relevant person is questioned, caution the person in the way required under the Responsibilities Code. In the present circumstances, it is submitted that the police officer failed to meet their statutory obligation to properly caution my client. This is an imperative obligation imposed upon police to maintain fairness and integrity in our justice system. Following this initial questioning, the police escorted my client throughout the surrounding neighbourhood in what seems like an attempt to elicit further admissions of burglary. As they did so, an exchange occurred whereby the police officer said the following in immediate succession, and I quote, "That one there's been broken into, did you do that? And this one up here, they were burgled a while back, did you break into that house? What about this one on the right? Is that one of the houses you broke into, Jimmy?" In response, my client concurrently nodded and said words to the effect, "Yes, sir, yes." Your Honour, I submit that my client was coerced into agreeing to the suggestive questions asked by the police due to the cultural phenomenon experienced by Indigenous persons called gratuitous concurrence. My client was intimidated and consequently misunderstood what was being asked of him. Furthermore, the police did not make an effort to procure from my client any signs of his level of intelligence, understanding, or even education. Any questioning prior to the formal interview at the police station was not electronically recorded, as required by Section 436 subsection 2 of the PPRA. Additionally, no written record of the admissions was provided. This is in direct violation of Section 437, subsections 4 to subsection 7. My client was then transported to a police station approximately 15 kilometres from his home. It was at the station that my client was assigned a support officer prior to his formal interview. If I could direct Your Honour's attention to Section 421 of the PPRA, which relevantly states, the officer must not question the child unless A. Before questioning starts, the police officer has, if practicable, allowed the child to speak to a support person chosen by the child in circumstances in which the conversation will not be overheard, and B. A support person is present while the child is being questioned. Your Honour, it is evidence under the present facts that my client was never given his liberty to choose a support person, and nor were his parents or guardian informed. Accordingly, Your Honour, I submit that the police have breached their statutory obligation due to this failure to abide by Section 421, subsection 2. Directly preceding the formal interview, the assigned support person instructed my client to, and I quote, "Make sure you answer the questions the police ask you." It was at this point that my client was denied his right to silence pursuant to Section 397 of the PPRA and Rule 26 of the Responsibilities Code. Your Honour, Section 5 of the PPRA highlights the purposes of the PPRA, and I read, "The purposes of this Act are as follows: to provide powers necessary for effective modern policing and law enforcement, to ensure fairness to and protect the rights of persons against whom police officers exercise powers under the Act." Your Honour, I submit that as a result of the action and omissions of the police, their aforementioned demeanour is a flagrant violation of the law and undermines the principal object of the PPRA. The very actions by the police in their dealings with my client is that which Parliament intended to legislate against. Consequently, I submit that my client has been subject to unfair and unjust treatment and that his rights under the PPRA have been grossly undermined. If I may direct Your Honour's attention to the decision of the court in Bunning and Cross, which was reaffirmed in Iron Island, and our authority for the basis of my submissions. The principles announced in Bunning and Cross allow Your Honour a judicial discretion to exclude the Crown's evidence on the grounds of illegality, prejudicial nature, and statutory breach. Your Honour, this court ought to exercise its judicial discretion propounded in Bunning and Cross to exclude the Crown's evidence for inadmissibility.